Hello, I'm Elias Borges, patent and trademark lawyer, and today I want to talk to you about protecting the three-dimensional design of your product. So let's assume you've created a new design for a cell phone. It has an interesting new three-dimensional design. It's much better looking, it has a lot of ergonomic advantages, and it has a unique design which you're thinking of applying to several of your products. Can that design be protected? Let's look at the type of intellectual property that might be available. So let's look at the types of intellectual property which might be available. The first is known as a patent. Now, in the United States, they're referred to as utility patents. Another form of intellectual property protection which would probably be available are referred to as industrial designs. Now, in the United States, they're referred to as design patents, but here in Canada, it's just referred to as an industrial design. A lot of you might be surprised to know that in some cases, you can actually get a trademark for the specific three-dimensional design of the product, and that's referred to as a trade dress or as a distinguishing guise. And in some cases, it may be possible to get copyright. So let's take a look at the first type of intellectual property protection, referred to as patents. Now, it is possible to get a patent for the 3D design of a product, but only the functional aspects of that design can be protected. And it's important to understand that ergonomics is a form of function. The design must be new, and most importantly, is it cannot be obvious from things which have existed in the past. So if you have a new design which is not obvious and it has functional aspects, like for instance, it has a certain ergonomic advantage, then it might be subject to patent protection. Now let's talk about some of the advantages and disadvantages with patents. Well, first of all, as I said before, the functional aspects of the design can be protected with the patent, and that's really the only way you can protect those functional elements is with a patent. The protection itself lasts up to 20 years. The protection that a patent grants you is actually fairly broad, so that if one of your competitors decides to make variations or changes to that design, it might still be caught by your patent. Unfortunately, there are some disadvantages. First of all, they can be hard to get. As I said, your invention has to be new and it cannot be obvious. It can also take a long time. We're talking a few years at least. And of course, if you're going for international protection, well, the costs are significant. Now let's talk about industrial designs. Again, in the United States, they're referred to as design patents. Now, this type of protection is specifically designed to help people protect the three-dimensional aesthetic elements of their design. So let's talk about that in greater detail. The first thing to understand about industrial design protection is that it only protects the aesthetic features of the design. That is, the three-dimensional look, the things that make it look interesting. That's protected with an industrial design. The functional aspects of the design are not protected. So if you have a design which is purely functional, it doesn't have any sort of aesthetic appeal to it, then theoretically it can't be protected with an industrial design. Like a patent, the features must be new and it cannot be obvious. Having said that, I've been doing this for 30 years now. I've only ever had 1 or 2 industrial design registrations rejected by the Industrial Design Office. So they're not that difficult to get. Well, there's certain advantages and disadvantages to industrial design protection. Like I said, they're easy to get. The other thing too is they're relatively low cost. It also doesn't take a heck of a long time to process the application after it's been filed. Unfortunately, the kind of protection you're getting only lasts about 10 years. And also, unfortunately, the protection is relatively narrow. That is, it protects that specific design. And if the competitor produces a design which is quite different in appearance, it won't be protected. Now let's talk about trademark protection. Yes, in certain circumstances, you actually can get a registered trademark for the three-dimensional look of your product. Let's explore that. So let's talk about trademarking a design. Well, when you trademark the look or shape of an object, it's often referred to as a trade dress or a distinguishing guise. And here's an example of one. Apple got a registered trademark for the three-dimensional look and feel of their iPhone, including the icons and the colors and the arrangement. Only the unique designs can be protected in this way, and again, only the non-functional aspects of the design can be protected. As for the sort of things that would be capable of being trademarked, it could be a unique shape, but it could also be a combination of colors, images, shapes, maybe even textures. All of these things taken together can be the subject of trademark protection. Now, like all other forms of intellectual property, there are advantages and disadvantages. Probably the biggest advantage is that it has an indefinite lifetime. As long as you keep using the trademark and you keep paying the maintenance fees, the trademark remains in force. The protection can be relatively broad. That is to say, if someone infringes on your trademark, all they have to do is make the design confusingly similar. It doesn't have to be exact. The cost is relatively low. Unfortunately, the trademark can be challenged either before the trademark is finally registered or even after. In particular, if you stop using your trademark, someone can expunge the mark by bringing certain proceedings before the trademark's office. Now let's talk about copyright protection. Yes, in certain limited circumstances, the three-dimensional design of your product may be subject to copyright protection. Now, copyright applies to original artistic works, so it does have to be an original work. And only the artistic elements can be protected using copyright. Functional elements are not included. Of course, copyright has a lot of advantages and disadvantages. First of all, it's just about the longest lasting form of protection that there is. Basically, the life of the author plus 50 years, depending on the jurisdiction that you're in. A registration is not strictly required in many circumstances, but it only applies to artistic works. So if you've got something which is of a purely industrial function, it probably isn't going to be covered by copyright protection. So in conclusion, there's a good chance that the three-dimensional shape and look of your product can be protected in one or more ways. First of all, if it's a functional design, then a utility patent might be available for you. If it's purely decorative, then an industrial design might be available to you. Again, if it's a new and inventive design. If it's distinctive, that is, it distinguishes your product from your competitors' products, then you might be able to get a trademark for it. And in certain limited circumstances, it might also be possible to get copyright. So that was a brief look at protecting the three-dimensional shape of your product using some form of intellectual property. If you have any questions or comments, please comment below. If you like this video, please like it. And I intend to create a lot more videos relating to intellectual property and other areas of the law, so please subscribe to my channel. I'm Elias Borges. Thank you very much for watching this video.